This is Floyd Abrams, and this is Speaking Freely. What I'd like to talk to you about today, speaking freely, is about the Supreme Court and about some of its recent rulings, some of which you surely know about, but a few you may not have focused as much on. I want to offer a general conclusion first. If there were an Olympic prize awarded, for which Supreme Court had in the briefest period of time reversed or undercut pre-existing decisions, what has occurred in the last week would give this court a claim to that prize: gold, silver, and bronze. Because they've done it in a variety of cases, in a variety of ways, but all pointing away from what had been the law, and all establishing either new law or changing old law in a way without quite saying it, which does just that. Of course, we're all aware of the reversal of Roe versus Wade. And I want to start on that simply by saying it was 49 years old. It was a case decided 49 years ago, which we have lived with. There has been controversy about it, but which everybody got used to, notwithstanding that there was considerable public debate all the time about whether it was rightly decided or not, and what the role of the Supreme Court should be with respect to abortion specifically, and where power ought to lie in deciding issues such as this. Did the Constitution, read in the 20th century and 21st century, did the Constitution permit the criminalization of abortion in all situations or not? Roe versus Wade had decided, of course, that that could not occur. And in our new world, there is no Roe versus Wade. There is no legal right to an abortion unless a state legislature or the Congress were to pass legislation with respect to it. I don't have to say, a very big case, but for now, I just want to emphasize that what the court was doing was striking down, overruling a prior precedent which had been with us a long time. And that's what they have been doing with enormous ease, enormous eagerness, I would say, for the last week in particular. Guns, weapons. New York State has had a law in one form or another since 1911, which required some sort of okay from the police or authorities to travel with, to carry weapons. They weren't very controversial laws for a long time, but now they are because of the reading that the Supreme Court gave for the first time a few years ago to the Second Amendment. And last week, the Supreme Court struck down, held to be unconstitutional, the current version of the New York law, which required some sort of official okay before someone could travel with, move around with a weapon. Religion. For an enormous period of time, it has been not debatable that the law with respect to the religion clause of the First Amendment both protected religion and protected against the state becoming involved with religion. The First Amendment begins with religion and then moves on to freedom of speech, freedom of the press, and freedom of assembly. And the law had been, and had been with great clarity, that schools in particular had to lay off, stay away from getting involved with teaching or endorsing a religion, one as opposed to another, or all as opposed to none. That was the law, and it was clear, and it was constitutionally rooted in the First Amendment. The catchphrase for us was separation of church and state. So, a few days ago, the Supreme Court had a case involving a football coach who chose to, of a public school, who chose to pray on the 50-yard line at the end of every game. This was a public school. They offered lots of other places where he could go to pray, but he wanted to pray on the 50-yard line. He is a member of the faculty. The school was arranged in a way so that the football field was part of the school. So on public school property, a public school teacher, coach, but teacher, was insisting against the wishes of the board and the like at the school that he wanted to pray on the 50-yard line as soon as the game was over. And he asked members of the team if they chose to join him. Not many years ago, I would say last year, and any year going back for a long time, it would have been really clear that that sort of behavior, of course, was fully protected for the coach to pray as he wanted and where he wanted, but not on school grounds. Nonetheless, and for the first time, the Supreme Court last week rendered a 6-3 opinion saying there was no coercion here. He was entitled to pray there, and in effect, that prior opinions dictating a greater separation between church and state were no more, were overruled, or if not literally overruled by name, simply didn't have the force they once did. That decision was a 6-3 decision. All the decisions I've talked about today were 6-3 opinions, with 6 conservative members of the court, including the 3 newest members of the court, being part of the 6, and 3 Democrats, liberals, call them what you want, on the other side. Justice Sotomayor, in her dissenting opinion, put the issue this way. She said, must a public school permit a school official to kneel, bow his head, say a prayer at the center of a school event? Now, part of the answer that the majority, the new conservative majority of the court gave, was the event was over. The game was over. The crowd, of course, was still there, leaving, but still there. The public school pupils on the team were, of course, still there, just as they had been. So Justice Sotomayor argued there's a sort of coercion, and there's certainly a push when the coach of the team says, I'm going to go out and pray now, but come on with me if you like. Until that decision, it would have been clear, undeniable, not debatable under then current law and law for many years before that what the coach insisted on doing, not privately, but publicly, and not disassociated from a game which attracted hundreds or thousands of people, but immediately afterwards, and on the 50-yard line, no less, couldn't occur in a public school context. If you can't have prayer in a school, you can't have prayer on school property, but is that still true? Well, certainly this Supreme Court has shown that in that case, the pre-existing law, the law as it had grown up, been developed, been generally accepted, was no more. And the same thing occurred in another case decided also within the last week in the religion area, which arose in Maine. Maine has certain extremely rural areas that are very hard to get to, and it has provided monetary assistance to students in doing just that. That assistance, so far, had been limited to students in public schools, not religious schools. The reason for that was that lots of Supreme Court cases in the past had said you can't fund religious schools with public money. Religious schools have all the rights of freedom, but consistent with the notion that we have a separation of church and state, that money could not come from the state, in effect, to the schools. So last week, the Supreme Court decided the opposite. They said, if the state is giving tuition assistance, or any sort of assistance really, to people in public schools, to kids in public schools, they had to do it as well with respect to children or the parents of children in religious schools. Another enormous break with pre-existing law and the tradition of separation of church and state, as well as that being embodied in the court's interpretation of the First Amendment. These are major steps, and the fact that these steps were taken after precedents, earlier cases had been on the book for years and years with respect to all these topics, makes the rulings of the new Supreme Court, the Supreme Court augmented by the 3 new members of the court, the presence of which has led earlier opinions by other judges, some of them quite conservative in every way that would then be used to define them, to be different, new. And the newness is a new interpretation of the First Amendment in a way which blurs, at the least blurs, the pre-existing proposition of law, well established in the law, that church and state have to be separate and that it benefits both of them, including religious institutions if the state is not involved in what they do, is not funding them, not defunding them, anything like that. So that's what's happened. There are a few questions one can ask about it, but the most pressing one, well recognized by critics of the opinion, and I think even the supporters of them, is, well, what's next? Where are we going as a society if all these changes have occurred and the law now is no Roe versus Wade, and the law now is guns may be carried freely throughout the state of New York, and the law now is, notwithstanding our previously adopted notion of separation of church and state, that more and more we're moving away from that separation. So where are we going? Not just what direction, but what sort of cases are we likely to have which raise issues stemming from or similar to, or which might require similar or different analysis than the Supreme Court has just been through. Justice Clarence Thomas, in his concurring opinion in the reversal of Roe versus Wade, referred to rather recent opinions of the court based on Roe versus Wade, opinions of the court with respect to marital privacy, for example. Are married couples entitled, as a matter of constitutional law, to purchase contraceptives at a drugstore? May a state pass a law saying not allowed to sell that? And the Supreme Court, years before, had said, yeah, it's part of the notion of marital privacy that a couple has the right to purchase contraceptives. And then, moving on from there as well, it's part of the same sort of juridical thinking which leads to that, to say same-sex marriage is protected under the Constitution. The government doesn't have the power. A state can't pass a law which bars same-sex couples from being married to each other. Well, what becomes of decisions like that? Are they now imperiled? That was one of the issues that the justices argued most about in the Dobbs case, the case reversing, overruling the pre-existing law set forth in Roe versus Wade. That was one of the things that was talked about and most important in terms of the future. I mean, what becomes of cases like that? And the short answer is, I mean, of course, we don't really know what the court will do, but, you know, it certainly sounds as if, I mean, reading the Dobbs, again, case that reversed Roe versus Wade, it sure sounds as if we're on a road away from constitutional protection of the right of gay people to marry, for example. Are they really going to do that? I don't believe they are, but if I'm right, they're going to have to engage in some tortured reasoning about why the same sort of approach that led them ideologically, or that they said led them to the decision reversing Roe shouldn't lead them as well to a similar decision with respect to gay marriage. We don't know what they're going to do about that, but they certainly could. They certainly could now take a major step backwards from the notion that people of the same sex have a constitutional right not to be discriminated against if they want to get married. And saying that they can't get married is a form of discrimination. These are the sort of issues that are going to arise in the future. And with the current Supreme Court, there certainly is more than a little reason, much more than a little reason, to think that the court is going to cut back significantly on liberty as we have come to know it in our society. I want to say a few words about the question of whether members of Congress were misled by statements made by the newer members of the court when they were interviewed. This has come to be a topic of a continuing discussion, and on this one, on both sides of the issue. I mean, one starts with the notion everyone in Washington understands that people who are up for confirmation stay away from controversy. They're taught, they're trained, they're told by the people and the supporters of the people who nominate them, don't say things, don't say anything more than you have to say of a controversial nature. And so, as you may have read, the issue has arisen was Senator Collins of Maine, in particular, misled by statements made to her by the newer members of the court, Justice Gorsuch, for example. And here's what I think. First, I think everyone in Washington understands the rules of the game are the individuals nominated for the Supreme Court in particular try enormously hard to stay away from saying almost anything. And they do. Justice Ginsburg famously said, I can't answer that question, I can't answer that question, because it may come before me on the court. And that sort of approach is one that members of the court have, people who made it to the court, have used through the years. But it's a little harder when you're in the office of a senator and the senator says to you, look, I really want to know, can I be sure that you're not going to just go on there and reverse Roe versus Wade? And the answers, the trained answers, I would say, the thought out, carefully answers, were ones which focused on precedent. We care about precedent. The court's already decided Roe versus Wade, and I take that very seriously. Indeed, the court has not just decided Roe versus Wade, Senator Collins heard. They've decided Roe versus Wade, and then another case, applying Roe versus Wade, which makes the ruling, if anything, even, this is my language now, less likely to be reversed. Again, and in all fairness, everyone understands the nature of the game in the sense that people who want to be confirmed try to say as little as possible. The interesting question here is, was she misled? Were other members of Congress who were voting and who were genuinely undecided misled? I think on the issue of precedent, the pre-existing law being very strong, that I think it's a tough sell for Senator Collins to say, well, I left thinking that they wouldn't reverse it because they kept emphasizing to me that it's a precedent, and indeed, at least in one case, it's sort of a double precedent. Precedent on precedent, because the court had said it not just once, but another time. It's not unfair to say she should have listened really hard, and she should have asked in so many words, well, what are you saying to me? Are you simply saying as a generality, a decision of the court is a decision of the court? Or are you really letting me know, ... Where I think that she was probably more specifically misled was that no one that talked to her, none of the candidates for the bench, indicated a level of hostility to Roe versus Wade, a level of rejection of Roe versus Wade, which they then signed on to in Justice Alito's opinion, which said Roe versus Wade was wrong the day it was issued. It seems to me if that's what you thought, if you're up for confirmation, and if you believe Roe versus Wade was wrong on the day it was issued, that it is not candid to speak as if it were a well-established precedent, and as if counsels of restraint were very great with respect to it. The word I would use is that it was misleading and inherently misleading and deliberately misleading. Again, I accept the proposition. One could not but accept it, that people who want to be confirmed try to stay away from trouble. They don't volunteer anything. They try not to lie, but they try not to say anything very interesting. But it seems to me if they were prepared to really say, not that long, not that many years after they were confirmed, that Roe versus Wade was just wrong. Wrong from the moment it was issued, always wrong. That it was more than misleading to leave her office thinking, or leave her thinking, that they were, pretty likely, very likely, at least not to be hostile, not to have rejected wholesale the decision in that case. A final thought. I found very interesting, I have found through the years indeed, very interesting, the way the Supreme Court has dealt with the most ambiguous of its amendments. The Ninth Amendment is one you may or may not have heard about because it's not been very important very often. The Ninth Amendment, part of the Bill of Rights, says that the enumeration of certain rights in the Bill of Rights should not be construed, quote, to deny or disparage the rights of the people. Deny or disparage. And it's always been unclear quite what that meant. Robert Bork, when he was being considered for the Supreme Court, said those words are like an ink blot. They have no meaning. It's as if literally the words under it were unreadable, so it doesn't have much in the way of meaning. But it does. When the Bill of Rights was first being drafted in 1798 in Philadelphia, the first question was whether we needed a Bill of Rights at all. And some very serious people, Alexander Hamilton for one, said the Constitution itself is a Bill of Rights without any separate listing of things Congress couldn't do or the newly empowered federal government couldn't do. And Hamilton presciently said, if we start listing things Congress can't do, in the future someone's going to say that's not on the list, or that's not on the list. So Hamilton said, let's not have a Bill of Rights. Let's not start saying Congress can't do this, Congress can't do that, Congress can't do that, because we're going to leave things out, and down the road, our forebears are going to wind up confused about what we meant. And what we meant is Congress can't do anything other than what we're saying they can do. Hamilton lost that fight. Fortunately, we do have a Bill of Rights. But although he lost the fight, the Ninth Amendment was written as an answer to that. The Ninth Amendment was written to say, the fact that something is not on the list doesn't mean it doesn't exist. The fact that we're not saying Congress can't do A, B, C, X doesn't mean that Congress can therefore do it. And the sort of argument that's gone on through the years about that is one of the most important ones, which I suspect the court is going to have to deal with in the years to come. What shall we make of social media, for example? Where does it fit? There's nothing in the Bill of Rights about social media because it didn't exist. Well, where might it be? Well, of course it might be. I think it is in the First Amendment. Congress shall make no law abridging the freedom of speech or of the press. But right now we have cases in the courts which will reach the Supreme Court for sure, I think, in which the question is, well, can a state, can Florida, can Texas, to pick two states that have done this, can they say, we're not treating social media as if it's the press. Social media is more like a telephone company. They're a common carrier. The people that run social media shouldn't be allowed to make choices about what to carry and what not to carry. That issue seems to me probably the most significant one in the area of free speech and free press that the court is likely to deal with in the years to come. And it'll be dealing with it sooner rather than later because of the importance of social media, because, as I've said, two states have already passed laws, Texas and Florida, which say in so many words that social media entities are not the press, that they are, again, they should be treated again more like billboards, more like other entities which simply carry speech, but which are not themselves speaking. How will the Supreme Court decide that sort of issue? An issue that I think will surely come to their attention. My own view is social media is press. It's 21st century press, period. They're entitled to the same sort of protections that newspapers are and were as far back as the 18th century when there were already newspapers. And I can only hope that whoever is on the court when that comes up, and I suspect it'll be all the same people who are there now, that they take a deep breath before they say that social media is not entitled to the same sort of protections that the New York Times and the Washington Post and CBS News are entitled. That's the case that I'm following the most these days, and that's the case that I think is most likely to have an enormous impact on First Amendment rights in the future.